Reed has been an attorney with LRB Thompson, working with expertise in personnel liability, personnel law. Does a fantastic job. If you are with GMA, LRB Thompson has had the HR helpline for many, many years, and Reed and his group handle most of the personnel related lawsuits that we have from a liability perspective. With that said, I'm really excited about this topic. I think the questions regarding Georgia and how we can manage guns is something that's, I think, first and foremost in many people's minds. So with that said, Reed, take it away.
All right, Dan, thank you very much. Can y'all hear me okay?
You sound good, Reed.
All right, good. All right, I didn't want to make any assumptions there. I hope everybody's having a good afternoon, and I appreciate your joining us for this this webinar. And Dan, thank you for your kind introduction. Again, my name is Reed Genelat, and I co-chair the LRB Thompson Public Sector Group, where we represent local governments primarily, but a few state agencies and educational institutions and whatnot in connection with labor and employment related matters. And I do a lot of private sector work too, but I have a great affinity for the public sector work. I like to, tell folks that are limited to the private sector that, our clients are subject to all the same laws for the most part that their clients are. But then on top of that, we've got to deal with a lot of these other constitutional and in some instances statutory restrictions that they don't have to encounter in the private sector. So we really have a lot on our plate when it comes to this stuff. And frankly, Georgia's gun laws are a good example of where our public sector clients have more to concern themselves with than our private sector clients do. Although the laws that we've seen enacted over the last several years have pretty much been game changers for all employers. As Dan said, I think that these webinars and presentations work well when there are questions being asked throughout the course of them, and I do encourage that, as did Dan. I will say that in this particular presentation, there may be some instances where I receive a question that is either something that is going to be covered, or it might be something that's not going to be covered, but the answer depends on so many different variables that I may need to, in order to really answer the question, I may need to speak with you or correspond with you after the webinar, which I'm very happy to do. I always hate it when anyone leaves one of these presentations or webinars with questions unanswered. So as part of the webinar, as a courtesy to LGRMS and its membership, I'm happy to make myself available to you for the next several days to respond to any questions you have. Of course, you can contact me or my partners at any time with any specific questions. Well, when we talk about Georgia's gun laws, we're principally talking about 4 statutes. These have been tweaked to some extent in the legislative sessions that came in between them. But one of the challenges that we have as lawyers trying to advise our clients with regard to the application of these gun laws is that, again, we're looking at primarily 4 separate legislative enactments, and they affect each other to various degrees. And one of the more complicating issues for us is that they're not codified in one common location. And so it really does require that you have a lot of different versions of these laws open, and you try to ascertain how they interact with each other. And sometimes it's fairly apparent once you've seen, read the 2 statutes together, and sometimes it's not apparent, and ultimately the courts are going to have to step in and resolve some of these things. In some instances, conflicts, perhaps, depending on the factual circumstances. So a lot of this, even though this first statute I've got listed here goes all the way back to 2008, a lot of these issues are going to ultimately have to be resolved by the courts, because every time there's new legislation, it really affects the interpretation and application of the pre-existing law. And I'll point some of the more significant aspects of that out as we go forward. But just a quick overview of these 4 laws. The first one is this Georgia Business Security and Employee Privacy Act of 2008. It went into effect in July of 2008. And folks that were a little worked up about it, or people in the media, referred to this as the Bring Your Gun to Work law, which is not necessarily an unfair nickname for it. It did create 2 general rules. One was that employees generally may bring the guns into the employer's parking lot or parking garage or parking facility, so long as they stored them in their own vehicles. Employers always have the right to restrict or prohibit guns from being in their city-issued or county-issued vehicles. Guns are maintained out of sight in a locked, according to the statute, trunk, glove box, or other enclosed compartment or area, which would include like a rack for a hunting rifle within the vehicle. And the other general rule that this statute created was that employees' personal vehicles cannot be searched in the employer's parking lot or facility or garage. And these rules also applied to invited guests of the employer, which presumably in the context of local government would be folks that have business with the local government. So 2 general rules, one relating to the right to store a gun in the privately owned vehicle, and the other one a right against being searched, or having the vehicle searched, I should say, simply because it's on the employer's parking facility. Now, these are general rules, so there's some exceptions built into them, where the parking lot or facility or the garage is secure, which under this statute means that public access is restricted by a gate or a security guard or something similar to that. Then under those circumstances, the employer is permitted to regulate or prohibit employees and invited guests from bringing guns into the parking facility. And one way to look at it, because this actually is something that is kind of a common theme with these statutes, is that the premise of these laws is that individuals are safe or safer if they're able to carry or have access to a gun, to their gun. And so if the employer does something to provide some security that is, arguably somewhat of a trade-off, that, provides some security for the individual so that the interest in having a gun on them or available to them is reduced, then that's where we tend to find some exceptions. So if we provide security with regard to the parking facility, then that gives the local government employer the right to prohibit the guns in the vehicles. Now, an important aspect of this is that the facility may have a portion that's open to the public, and then a portion that's for employee parking. And as long as the portion that's dedicated to employee parking has this security, then this particular exemption or exception is applicable. As I previously mentioned, another exception is where the vehicle in question is actually owned by or leased by the public employer and assigned to the employee. Under those circumstances, the right to regulate or prohibit the gun from being in the vehicle remains with the employer. And then as a general rule, this general rule that employers or others have the right, when they have reasonable cause to believe that a vehicle search is necessary to prevent an immediate threat to safety. Under those circumstances, you can bypass the prohibition on conducting searches, but obviously you're going to have to, as an employer, articulate what that reasonable cause is. And so the more objective the reasons are, the better off you are in being able to show that the search was reasonable, because that is something that folks may choose to pursue legally. And this is an important one here at the bottom in terms of exceptions as to when employers can prohibit or restrict employees' right, the general right to bring a weapon into the parking facility, is where the prohibition is imposed on the employee as part of disciplinary action, whether it's ongoing or a completed disciplinary action. This particular issue, as far as I'm aware, has not been litigated. So my guess is that the discipline, if you were to impose this restriction or prohibition on an employee as part of disciplinary action, there probably would have to be some nexus between this prohibition or restriction and whatever it is that the employee did to warrant the imposition of discipline. So if an employee is simply tardy or has too many absences or something of that nature, that's probably going to be difficult to connect to imposing this prohibition on them with regard to bringing guns into the parking facility. On the other hand, if there's anything that suggests something in the nature of workplace violence, a fight, or something that suggests anger issues along those lines, then I think you're in a better position to use this. But this is a good example of an exemption that would be good to run by your city or county attorney or contact your helpline to get guidance on. And you'll probably hear me say that a few times, because there are very few areas of these laws that are crystal clear. Okay, I'm getting a little bogged down, so I'm going to try to speed up a little bit. The most significant of these laws that we've seen in the last several years is this Georgia Safe Carry Protection Act of 2014. And this is the law that was referred to as the Guns Everywhere law, because it significantly changed the places or expanded the places where folks could carry weapons and guns over existing law. So this one was probably the most controversial of all the laws that were passed in the last few years. And I will say this, and I think I might get some pushback from folks who represent restaurants and bars, but I think that this statute affected local government employers more so than any other group out there. And it's been affected significantly by the newest law that I'll mention in a little bit here. But continuing with this particular 2014 law, the Guns Everywhere law, so to speak, it placed emphasis on this weapons carry license concept, and which you'll sometimes hear referred to as a permit, but it allowed individuals to obtain a weapons carry license as long as they were 21 years old or older. There was an exception for folks who were 18 and could show that they had been in the military or are in the military and had completed basic training. Under those circumstances, they were allowed to be issued weapons carry licenses before their 21st birthday. It's also restricted to Georgia residents, and there's a requirement that you either be a U.S. citizen or at least a lawful resident of the United States in order to qualify for a weapons carry license under this 2014 legislation. Continuing on with it, in order to qualify, or additional requirements for qualifying for a weapons carry license, and you'll see in parentheticals there, I have WCL. You'll see that every now and again in articles and whatnot that you may read about this particular law. It stands for the weapons carry license. But there's also a requirement that they have no what we call disqualifying convictions or pending criminal proceedings. If they have pending criminal proceedings, the probate courts are typically going to wait to see how those come out before they issue the weapons carry license. But the disqualifying convictions are any felony at all, and then misdemeanors that are drug related or pertain to domestic violence. Those are considered disqualifying in terms of weapons carry license issuance. And then finally, there's the requirement that the the applicant for the weapons carry license not have been involuntarily committed to a mental hospital at any time, or that they not have been voluntarily admitted to a mental hospital or a drug or alcohol treatment facility or center within 5 years preceding the application for the weapons carry license. All right. In 2017, another slightly controversial statute was this Campus Carry Act, and it for the first time allowed people with weapons carry licenses to carry handguns into areas of public colleges and universities, not high schools, middle schools, and whatnot, under certain circumstances. I'm not going to go into all the different restrictions that are imposed there, but they'll be in the handouts that Dan will tell you how to get a hold of. Then our most recent law is the Georgia Constitutional Carry Act of 2021. I'm not sure why we call it 2021, because it wasn't enacted until 2022, went into effect last month. And it, when you look at the fact that it made Georgia the 25th constitutional carry state in the country, it doesn't seem all that remarkable. But its uniqueness is in the fact that it impacts the prior laws that the legislature has enacted. Primarily this 2014 law, which, as I mentioned, was called the Guns Everywhere Act, because of how much it broadened the areas, the places where persons could carry weapons. Now, again, the title of this statute is the Constitutional Carry Act, and the concept of constitutional carry refers to a person's right to carry a concealed firearm without government permission. All right, so that's a little different from this notion about the weapons carry license. So under this new law, what we're saying here is that persons who were eligible under that old law to obtain a weapons carry license, and we went down the list of things, age restrictions and restrictions regarding criminal history and residency and citizenship and all of that. If you qualified under that prior law to obtain a weapons carry license, then you also qualify under this new law to carry a weapon, to carry a gun without obtaining a weapons carry license. All right, so what we refer to these folks as are lawful weapons carriers. So it's interesting that, we will sometimes see this abbreviated as LWC, which can be confusing when we talk about the WCL, which was the weapons carry license. But there's some symmetry there, because a lawful weapons carrier is somebody who, under the old law, would have qualified for a weapons carry license. So that's an easy way of looking at it. There's no longer a requirement that you actually apply for and obtain a weapons carry license, thanks to this new law, but the requirements of being a lawful weapons carrier are the same as the requirements that used to be in place for obtaining a weapons carry license, if that makes sense. Now, what's perhaps either interesting or further confusing about this, depending on your perspective, is that while this new law did away with the requirement that you have a weapons carry license in order to carry a weapon, carry a gun, it retained the program. You can still go and apply for a weapons carry license or a permit, just as you could just as you were required to do under the prior law in order to carry a weapon. And the reason for that is that there are states out there that will grant reciprocity. If you are from a state such as Georgia, obviously, that has enacted constitutional carry, and Georgia grants reciprocity rights to residents of other states under these same circumstances. Some of these states are going to require that you have a weapons carry license in order to be entitled to the reciprocity. So there's still some reason why, if you travel out of state or go on hunting trips or whatever it may be, there may be other reasons why you would want that reciprocity, and so it still makes sense to maintain the weapons carry license and renew it, even though the new law doesn't require it, at least while you're within the state of Georgia. So interesting tidbit there. And one thing I pointed out at the beginning of this particular presentation is that the Constitutional Carry Act is really the combination of a Senate Bill 319, which is the main part of it, and this House Bill 218, which is has to do with the reciprocity requirements. So if you pull the Senate bill and you don't see the reciprocity stuff that I was just referring to, it's in the House bill that kind of accompanies it. All right. Now, a couple important points with regard to the law as it currently exists as a result of this new Constitutional Carry Act being enacted earlier last year. I said last month a while ago. My head's still in 2022. It was enacted in April of 2022. So we still have this federal law that's applicable, this Brady Handgun Violence Prevention Act, and it requires that firearms dealers conduct criminal background checks in connection with the sale of a firearm. That law does not apply to private transactions. So there's a pretty significant loophole there. Also, firearms transfers to persons who are either convicted of serious crimes, and in Georgia, we've already talked about how those are defined, felonies or any crime related to domestic violence or drugs, or any person who had been adjudicated as having a mental illness are prohibited under this Brady law. And there could be some prosecution there for anybody involved on the wrong side of one of these transactions. All right, so let's get into some specific issues. I'm going to be focusing these primarily on personnel-related issues. Although Lord knows these laws implicate a lot of other areas. So one of the questions that we get, does Georgia law allow local government employees to carry guns in the workplace? Well, the answer to that is yes, initially. There's a presumption that this new law creates that the local government employees are allowed to carry weapons into the workplace. But at the same time, the law authorizes local government employers to adopt policies that restrict or prohibit employees from bringing guns into the workplace. One thing that's very important to understand is that if you don't have a policy, if you're an employer and you want to prohibit employees from bringing guns into the workplace, you've got to enact a policy to that effect, because until you've done so, the presumption that the combination of these laws creates is that employees can bring their weapons into the workplace, their guns into the workplace. So the policy is important. The law doesn't specify that it needs to be in writing, but there's about 500 reasons why you definitely would want it to be in writing. One exception to this rule with regard to local government employers and their general ability to prohibit or restrict employees from bringing guns into the workplace, and that relates to law enforcement. So in the legislature's view, the police chief or the head of whatever law enforcement agency is part of your city or your county or your organization is deemed to be in the best position to decide what rules and regulations, restrictions and limitations and even prohibitions to impose on his or her employees. And so local government employers are not allowed to dictate to the head of the law enforcement agency, police department, or whatever it may be, how they're going to enact those policies. And that's true both for their sworn and their unsworn personnel. All right, does Georgia law allow local government employees to carry guns when outside of the workplace, but while they're still on duty? Well, the same rules apply, which means there's a presumption that yes, they would have the same rights as any Georgia resident under those circumstances. But once again, local government employers are allowed in these policies that we were talking about a moment ago. They can extend these policies to prohibit or restrict the ability of employees to have access to or be in possession of guns while they're on duty. And again, the exception to the exception for law enforcement is also there. So the law doesn't really make a distinction between the workplace and employees who are on the clock, but they're off the workplace for whatever reason. So as long as the local government employees are either on duty or otherwise acting in the course of their employment, which is, for my money, just another way of saying the same thing, then the policies of the local government employer restricting or prohibiting the gun is permissible. All right. Next question. Does Georgia law allow local government employees to carry guns when off duty and when otherwise not acting in the course of their employment? And as you might imagine, the answer to this question is really no. This is where the legislature determines that the local government employer does not have an interest in regulating the off-duty and off-premises conduct of their employees. So long as they are a lawful weapons carrier, which means they meet the requirements that we went through for holding a weapons carry license under the prior law, and the reference back to slides 6 and 7 is where you'll see those listed if you obtain the PowerPoint from Dan. If they're off duty and not acting in the course of their employment, and if they're otherwise acting entirely as citizens, then the local government employer is not in a position to extend any policies towards them with regard to the restriction or prohibition of the guns. Now, a little bit more on that, where we've seen a couple of instances of confusion with our local government clients. This restriction on the right of the employer to impose restrictions on its off-duty employees, it includes areas where the employee would not be permitted to carry a gun if he was on duty. And the example I've put here is actually one that we had to deal with, which was a public works employee, or I'm sorry, a Parks and Rec employee, who would not have been allowed to carry a gun while on duty, working in the parks. But when he's off duty and he wants to visit the park in his capacity as a citizen or a resident, he's allowed to carry it. So it's a little weird in that sense because it's the exact same place, but that's how this works. If he's clearly in his capacity as an employer, as a citizen, I should say, then he's got the same rights as any other citizen with regard to where he carries the weapon, assuming he's a lawful weapons carrier. Now, I've mentioned this before with regard to the parking, but local government employers retain the right to prohibit employees from carrying weapons in any sort of take-home vehicle, whether they're on or off duty. So if the vehicle is owned or leased by the local government employer and assigned to the employee, then if they're allowed to drive the vehicle off duty, you can continue to prohibit them from having a gun or other weapon in the vehicle, even if they're off duty. All right, now here's an exception that we've worked with one particular client that had a unique concern, and that is that their employees tended to wear their uniform, not law enforcement or firefighting uniforms, but they would tend to wear a uniform shirt or a shirt that identified them as an employee of the particular city or county, maybe a hat, or have just something else associated with the city or county or other local governmental employer that they work for. So they would wear these things while off duty, and they would be exercising their constitutional carry rights at the same time. And the concern was that people observing this might think that they're on duty and that they're allowed to carry a weapon as part of their jobs and whatnot. And that type of confusion is not ideal, or those types of assumptions being made by people that view this are not ideal. And so we put together a policy that restricted the rights of the employees not to carry a gun or weapon lawfully off duty, but to do so while wearing uniforms or anything that would associate them with the city or county that they work for. This has not been tested by the courts. And so, to some extent, it arguably is imposing a restriction on somebody who's exercising their rights under the statute, and that's normally a red flag. But there are some pretty strong public policy reasons for doing it. Particularly if somebody is wearing a uniform shirt and a hat for your organization, and they're off duty and they're in a restaurant or they're in a grocery store when someone pulls a gun and tries to rob it, and then they pull their gun and it doesn't go the way they'd hoped it would, and some innocent person is wounded or even worse, killed by the off-duty employee, then I can just tell you as a member of the species that lawyers, they're going to look for whoever they can sue. And I'm a defense lawyer, so that's not my instinct, but I've been around it enough to know there's very little chance that they're not going to include the city or the county in that if there's reasonable belief that the off-duty employee was in some form or fashion representing the city or the county because of the uniform and the hat and all of that. And even if you're able to get out of those cases pretty quickly, it's still expensive. And so there's good reason to consider a policy to that effect. All right, next question. Does Georgia law allow local government employees to keep guns in their personal vehicles while parked in the local government employer's parking lot or garage? Now, this is part of this Georgia Business Security and Employee Privacy Act law 2008 that we talked about, the one that they called the Take Your Gun to Work law. And I'm just going to touch on a couple of these points because we've already covered some of them. But the general rule is if the lot or the garage or the parking facility is secured, which again, remember the analysis, that's sort of a substitute for somebody having to potentially protect themselves with their own gun. So if the lot or the garage or the facility is secure, the local government employer can prohibit the employees from keeping guns in their personal vehicles in that facility or in that lot. It only applies to that portion of the lot or garage that's actually being used by the employees. In other words, if the lot has a public parking aspect to it that's not secured, that's fine so long as the area designated for the employees to park in is secured. That partial security is sufficient to allow the employer to prohibit the keeping of guns in the parked vehicles. And secured, as we've already talked about, means that public access is restricted in some way by either a security officer or a gate or a security station of some kind, something along those lines. If the garage is unsecured, if the parking facility or garage or parking lot is unsecured, then the opposite is true. The employees cannot be prohibited from keeping the guns in their personal vehicles, assuming, of course, that they are lawful weapons carriers, which is more of a legal issue than a personnel issue. And then there is a restriction on the right to keep the car in the vehicle, and that is that it be locked and secured out of sight in a compartment such as the trunk or glove box. And it says, except when entering and exiting the lot or garage, that just recognizes that the employee is allowed to have the weapon more accessible to them while they're driving. And so they can pull into your facility and then secure it once they get into their parking spot, and they won't be in violation of your prohibition if you have one in place. All right, next question. Does Georgia law allow the general public to carry guns into the local government workplace? And This is not so much a personnel issue. There are numerous personnel issues that stem off of this, which is why I wanted to include it. So I'm going to touch on some aspects of this, and then we'll talk a little bit about the personnel issues that may come out of this. So the general rule is that a lawful weapons carrier is allowed to carry a gun into a local government workplace, at least on days and times when the workplace is open for business, unless an exception applies. So remember, again, a lawful weapons carrier is somebody that would have qualified or who would qualify under the 2016 law. Yeah, it's 2014 law. I keep calling it 2016, but 2014 law for a weapons carry license. The same requirements attached to lawful weapons carrier status as attached to the weapons carry license under the prior statute. Now, we're going to talk about the exceptions in a minute, but I want to reemphasize the fact that ever since this latest law, the Constitutional Carry Act, was enacted, there's no longer any distinction under Georgia law between a holder of a weapons carry license and a non-holder of a weapons carry license, provided the non-holder would qualify for one if he or she wanted one. That's within the state. Again, there could be some significance to reciprocity outside of the state, but within the state, there's no longer a distinction between somebody who has a weapons carry license that they qualified for and they still qualify to hold, and someone who does not have a weapons carry license, but they would qualify for one if they chose to get one. Now, here's some of the problems associated with this: is that a person cannot be detained, and that doesn't mean arrested, but it just means stopped and asked questions. They can't be detained solely for the purpose of determining whether they're lawful weapons carriers. So that's a little frustrating for local government employers that allow access to their facilities to lawful weapons carriers if you're not really in a position to determine whether or not somebody is a lawful weapons carrier. Now, that doesn't mean that you have to ignore, if you are perfectly aware that somebody that is wearing a sidearm is 16 years old because he's got the same birthday as your daughter and you all grew up, your kids grew up together in the same neighborhood. You don't have to ignore that because that's reasonable cause to believe that there's that person is not a lawful weapons carrier because he's too young. So you can act on that, but you can't ask questions and detain somebody to see if there is reasonable cause to believe. You have to have reasonable cause before you act on that. So this next point is a little frustrating, but persons carrying guns into government buildings, they can be asked to display their weapons carry license, but the problem with that is they don't have to do it. They don't have to comply, and ever since this new law was passed, they're not even required to have a weapons carry license. So this is a next to useless right that local government employers have to make these inquiries. To ask someone whether they have a license or a permit, they don't have to answer you, and even if they do answer you, they're not required to have one. So, and then as I mentioned a moment ago, detaining somebody and asking additional questions relating to whether you should allow them access to your facility, your building, your workplace, requires some kind of reasonable suspicion that a crime has been committed. Whether my example of the person with the gun clearly being too old, too young, because you or somebody that's provided the information to you is aware of their age, or there's just something else going on. The person's spouse works within the works for you, and there's a protective order in place, and he shows up with a gun or she shows up with a gun. That's reasonable cause to be concerned that a crime has been committed or is about to be committed, and that would support detaining somebody and taking some action. Those are opposite extremes of the examples, and there's several in between there. Now, I inadvertently deleted a slide here. So it says security personnel exception continued. the slide that we would be looking at, but for my itchy trigger finger, no pun intended, would have mentioned that probably the best known and the most common exception to this rule that members of the general public, at least those who are who are lawful weapons carriers, are allowed access to the local government workplace. The most common exception is when the entrances to the local government workplace are secured, screened by security personnel. Okay, when you're able to, staff the entrances, the public entrances to the facility, the building, whatever it is, with security personnel, then under those circumstances, you're allowed to prohibit individuals from bringing guns into the workplace. And it works just like what we were talking about earlier with the parking facility or parking deck, parking lot. If there's some reasonable substitute for the employee or for the member of the public being able to protect themselves by having their own gun with them, then you can infringe upon their constitutional carry rights, at least a little bit. So in this instance, the notion is that having a security personnel at the entrances is that substitute, and therefore is sufficient to allow you to prohibit the individual from bringing the gun into the facility. Now, in my experience, this is for most of the local government clients that we've worked with and talked to about this particular exemption or exception. It's tough for them to free somebody up to staff the entrances, particularly if there's more than one public interest entrance to the building. So this can be a difficult exception to take advantage of, but it is the primary one and the one that's most often used in our experience. So going on to this, what would have been the second slide relating to this, security personnel need not be certified peace officers. So these don't have to be post-certified individuals. Although a side note is if they are not post-certified, if they're not police officers or law enforcement officers, then if somebody tries to enter the facility without a weapons carry license or otherwise tries to make their way in, even though there's security personnel there, they may or may not be able to be criminally prosecuted. If you have a post-certified officer there, and that officer would not like that assignment, I can assure you, then you have greater flexibility in terms of prosecuting somebody that tries to barge their way into the facility. But thankfully, the legislature did not require that these be post-certified individuals in order to make this exception work. Now, with regard to employers that have more than one public entrance, if you've only posted your security personnel, at the main entrance, that's probably not going to cut it. In our view of this, after looking at the statute, we think that all of the public entrances have to be secured by security personnel in order for this exception to apply, unfortunately. And that's one of the things that makes this a very difficult exception for some of our local government clients to take advantage of. Similarly, if the security personnel are not there at all times, if there's only certain times of the day that they're there or certain days of the week that they're there, we think the prohibition or the right to prohibit guns in the workplace still applies, but only on those dates and only on during those time periods when the security personnel are present. Not really sure how this would play out if somebody got turned away and had to put their gun back in their, secured in their car in order to enter a building because there was a security personnel there. And then when they come out and completed their business, turns out the security personnel have left because they were scheduled to leave 15 minutes earlier. I don't know that there's any damages there, but it could be something that somebody challenges. But right now, our belief is that you can take partial advantage of this exemption by partially occasionally having individuals at these serving as security personnel at the public entrances to the buildings. Now, also, if the we've helped out a couple of our local government clients that have multiple entrances with this approach, and that is that if there's certain parts of the building that can only be accessed by people entering the building through one entrance, and that's the entrance that you have the security personnel stationed at, then we believe that you can take advantage of the prohibition on the general public bringing guns into the building as to those areas that are protected, so to say, by the security guard. So you could have part of your building that is not protected by security personnel, depending on the entrance that the members of the public use, in which case no restriction can be applied on the right to bring the gun in unless an exception applies. And then you'll have another portion that is protected, and therefore you can apply the restriction. So there's a couple of different ways to work around this if you want to do it, and you have the problem of multiple entrances. Okay, now as I mentioned before, there's other exceptions. So local government employers can still prohibit individuals, members of the public, from bringing guns, and frankly, the law already prohibits this, bringing guns into courthouses or jails or detention facilities or prisons, regardless of whether they're restricted or screened by security personnel. Although certainly many courthouses and many jails and detention facilities and prisons tend to be protected in that sense. There's no prerequisite of that. These are just places where guns are not allowed. And the definition of a courthouse is particularly useful because it provides a bit of a loophole for some local government employers that want to prohibit, or at least restrict to some extent, the rights of the members of the public to bring guns into the workplace. And so the definition, as you see here under this first sub-bullet, is for courthouse is that it's a building occupied by judicial courts and containing rooms in which judicial proceedings are held. And so what's important about this definition is that the courthouse could literally be just a very small portion of the overall building. If you've got a room that serves as the courthouse, and there's a room next to it, an office that serves as the judge's office, and maybe there's another office where other court personnel, court clerk or whoever it may be, are stationed, and it could be that they're only there during certain times when court is in session. And I know a lot of municipal and magistrate courts are not 5-day-a-week courts. The statute doesn't differentiate. So what I'm getting at is that if the building has a courthouse in it, and it's got to be a judicial courthouse, not administrative, but if it's got a room in it that is used for conducting judicial proceedings, and other rooms that house members of the court, the judge, and whoever it may be, then that's enough to impose a prohibition on bringing guns into that building. So if your municipal court, for example, is in the same building that is your city hall and has all your other municipal offices and departments in it, then you actually can invoke this provision, as we interpret it, to prohibit members of the public from bringing guns into the entire building, even without a security personnel at the entrances. We would encourage you to speak with your city or county attorney, or you can call your county helpline or call us if you're members of GRMA, or frankly, we're happy to talk to any of y'all about these issues. We think that if you're going to approach this, take this approach, there's certain things that you may want to do to protect yourself in the event someone disagrees with our interpretation of this, and we can help you implement it. But as it stands right now, we think this is a probably unintended loophole that allows for local government employers to prohibit members of the public from bringing guns into their facilities. We've had at least one local government client that I'm aware of, and probably others, who have actually relocated their court operations into their main buildings so that they can take advantage of this. All right, so does Georgia law allow local government employees to refuse to serve or interact with members of the public exercising their right?
Reed,
Yes, sir.
got a question.
All right.
Are there any exceptions for polling places?
Yes. Excuse me. I do not know enough to speak to it specifically, but I'm happy to look it up and answer that question for that person more with more detail. But yes, the polling places have been protected, I think, even long before most of these statutes have been in place. So yeah, the concern there, apart from safety concerns, is the potential for intimidation and whatnot. So there's definitely a prohibition. I couldn't tell you how many feet off the top of my head, but whoever has any specific questions about that issue, please reach out to me. My contact information is in the handout materials, and I'll be happy to give you the exact answer to that question. I'm sorry I don't have that in front of me right now. Okay, so an issue that we have come up a lot with regard to the issue of members of the public being allowed to come into the local government offices is, what do you do with the employees? And you know, given recent events, this is not a terribly uncommon situation, particularly if with some of our customer service representative type employees who have to interact with individuals who are upset for whatever reason. Now that, you know, you can look down and see that someone is carrying a gun and they're angry at you, this does tend to increase the concerns, understandably so, of certain employees. So the question of whether a local government employer can require its employees to interact with persons who are exercising their constitutional carry rights, the general rule is yes, if the employee's duties and responsibilities include such interaction. And I would probably reword that to say that yes, especially if the employee's duties and responsibilities include such interaction, because there could be times when somebody, an employee who doesn't normally interact with members of the public, might be asked to do so by a supervisor for some reason or another. And normally you would expect that the employee would comply with the directive from a supervisor with the authority to give that directive. But we do believe, given where we are with everything now, that the best practice when an employee expresses some concern, and you know, we're hoping they're not flat out refusing to do it, because that makes it a little bit more difficult. But I think if an employee does refuse to do it, the best thing to do is, initially at least, is to treat it as if they're expressing a concern about interacting with a member of the public who's exercising their right to carry. And so we don't want to ignore that ever. And so we want to find out two things. One is, you know, is there a specific reason why the employee has got this concern? Is there some reason that's specific to this particular interaction, to this particular member of the public? You know, has he or she threatened the employee in the past, or has been known to threaten people, or somebody that may have engaged in some violent behavior in the past, although presumably not bad enough to disqualify them from being a lawful weapons carrier. And just hear what they have to say. It could also be something that could implicate ADA issues. Anxiety is certainly something that we're seeing more and more of, particularly post-pandemic, and now with so much in the news about some of these shootings that have been happening. We're probably going to be seeing more and more of it. And so we're going to want to handle that as a potential ADA situation with the interactive action, and perhaps sending somebody off for an assessment so we can determine whether or not we're actually dealing with a disability and figure out what our obligations to them are. and I don't want to turn this into an ADA presentation, but you need to be mindful of these two issues. One is that we don't, the worst thing, that could happen from a liability standpoint would be for an employee to express some specific concerns about interacting with somebody who's got a gun, and then that person is forced to go interact with them anyway, and something terrible happens as a result. We do not want to be in that situation. We don't want to put the employee in that situation, obviously. And then, we're sort of expecting that we're going to be hearing from more employees who are going to be expressing anxiety that may or may not qualify as a disability when it comes to interacting with people with who are exercising their rights to carry. Now, in doing this is sort of the tricky balancing test. We want to deal with these issues with the employee, but at the same time, we cannot ignore the lawful weapons carrier or the LWC's rights. We don't want them to be infringed upon. It's not good if they have to wait 30 minutes while we're trying to sort through all of this. Whereas if he'd walked in there without a gun on his hip, he would never have had any of those problems. So that's something we need to be concerned about too. We got to strike the right balance between dealing with the employee and also ensuring that we're not giving the lawful weapons carrier any reason to believe that he or she is being discriminated against for exercising his rights. So some of the things that we've suggested for clients that have contacted us with these issues is to consider allowing an employee who has a reasonable, particularized concern, in other words, not just a vague concern about people with guns, or a verified anxiety, which actually could apply to anybody with guns if it rises to the level of disability. Consider allowing them to request accommodations from a supervisor, such as having a coworker take over that particular interaction or accompany the employee during the interaction. One thing you can do, which is a little dangerous because it comes pretty close to infringing upon the rights of the legal weapons carrier, and that is to consider relocating the interaction to a building or an office where the guns can be prohibited. An example would be a courthouse. So if it's going to be some sort of a meeting and the employee is expressing concern that the meeting is going to be heated because they have a pretty good idea it's not going to go the way the member of the public is hoping it's going to go, and this member of the public is known to have a temper or whatever it might be, then maybe the thing to do is move the meeting into one of these areas where you can prohibit the gun. But here again, we don't want to ignore the fact that the legal weapon carrier has rights, and we don't want to give them any reason to believe that we're discriminating against them. So this is a difficult balancing test. These laws are too new for the courts to have had a chance to weigh in on where these lines are drawn. But we do tend to suggest that clients err on the side of safety and err on the side of protecting their employees' ADA rights. These are at least non-discriminatory reasons for perhaps making the legal weapons carrier wait a little bit longer or meet in a different room. And at least we can go into the courthouse with a straight face, look the judge in the eye, and explain why we did what we did. So until we get more guidance from the courts, that's the advice we're giving, is that we err on the side of safety and compliance with the federal law over the state law. All right, so we're right at 3 o'clock. One of these days I'm going to finish one of these PowerPoints. But what I'd like to say is that there are a number of other slides that I think you might find interesting. Those of you that are in public and private partnerships, or who have delivery folks or vendors or independent contractors who are almost like employees of your city or county organization because they're there so often. If you want to prohibit them from bringing weapons into the facility, you can't treat them as employees, and so you don't have that right that you would have with your regular employees. But you may have some options in terms of interacting with their employers, and so that's something that we or your city or county attorneys can help you with if that's a concern of yours. Um, and lastly, let me just say this and encourage you to look at the materials as well on this, because one question that arises is the extent to which Georgia law requires local government employers to take additional security measures to provide a safer work, a safe work environment for their employees in light of the way these gun laws are evolving. And the answer to this question is not very satisfying, because first of all, the gun laws don't impose any such requirement. Again, the principle underlying, or one of the public policy principles underlying these laws, all of them, is that safety is enhanced by allowing folks to exercise their constitutional carry rights. And so, it's somewhat inconsistent with that to require that employers or any other entity take special security measures outside of the specific issues that we've talked about, such as jails and courthouses and polling places and that sort of thing. The gun laws authorize certain security measures to be taken, such as the having a security personnel at the entrances. And we talked about the parking lots and whatnot. You can do these things, but the laws don't require that you do them. But the question is, does Georgia law in some other respect require that you take additional measures if the game has changed? We've got guns, are more prominent, more prevalent in the workplace than they were previously because of these laws. And so just because these new laws themselves don't speak to it, does that mean that we don't have some obligation to take additional safety measures based on other laws? And that's a very good question, because Georgia has long had in place this statute here, which I'm just going to read real quickly. It says, every employer shall furnish employment which shall be reasonably safe for the employees therein, shall furnish and use safety devices and safeguards, shall adopt and use methods and processes reasonably adequate to render such an employment and place of employment safe, and shall do every other thing reasonably necessary to protect life, health, safety, and welfare of such employees. So this is a codification of the duty of care that you may have heard of before in the context of negligence, which is typically what the cause of action would be if something terrible happened. The question would be whether or not the employer met this standard articulated by this particular statute in terms of whatever security measures it has in place. So, the gun laws allow you to put security personnel at your entrances and thereby prohibit members of the public from bringing guns in, but it doesn't require it. But is it possible that this statute might require it? Well, it's not impossible. And one thing I would also point out is the first of these four laws that we've been talking about, actually, spoke to this issue, that being the Business Security and Employee Privacy Act from 2008. There's actually a provision in that particular statute that says this code section shall not be construed as to require an employer, property owner, or property owner's agent to implement any additional security measures for the protection of employees, customers, or other persons. So the legislature was tuned into this in 2008, and they wanted to put a stop to it. They wanted this law to enhance safety and to enhance Second Amendment rights, and they didn't want to see, as a result of that, an increase in lawsuits being brought by folks who claim that they've been injured as a result of an employer's negligence in not maybe securing the parking facility and prohibiting employees from bringing guns into the parking facility. But I don't know whether it was intentional or not, but in the several laws that have been passed since this 2008 law, there's been no comparable provisions incorporated into them. Again, they make these security measures optional, but they don't include this language here that actually would provide a legal protection for a local government employer or any employer that's sued for negligence in connection with a gun-related injury. So there's a couple of things that we list in here. I'm not going to go through them. I do encourage you to get a copy of the handout so you can see this. But there's certain steps that can be taken depending on whether you consider the workplace to be safer if employees are allowed to have guns versus if you exercise your right to prohibit employees from having guns. But once you work through that, and this is the last point I'll make, if you determine that you're going to allow employees to bring guns into the workplace, the law allows you to prohibit that. So that means you're allowed to 100% burden the right to carry when it comes to your employees in the workplace and otherwise on duty. So if you can 100% burden it, then you can 50% burden it. That's the general rule. None of this has been tested in court yet, but in the context of these laws. But as a general rule, if you can completely prohibit something, you can usually restrict it. So what we're suggesting here is that you may, if you're inclined to allow employees to bring guns into the workplace, then perhaps you can condition it on their having gun safety training, saying, we'll allow you to do it, but only if you every year qualify under this gun safety program. There are other things that we do know you cannot do. You cannot get an employee who doesn't have a safety sensitive position to agree to random drug testing as a condition of bringing a gun into the workplace. That is not permissible. And by the same token, you can't require them to go through a psychological examination as a precondition, because that probably implicates some constitutional provisions as well, but it would certainly be a problem under the ADA, which requires that you have an articulable job-related reason for requiring a psychological exam of your employees. So there's some other suggestions in here, but I'm going to go ahead and wrap up now. We're 8 minutes past my stopping time. If I haven't lost all my attendees and anyone wants to ask any questions now, I'll be happy to try to answer them or make note of them and get back to you with the answer.
Anyone have any questions? Reed, great job, by the way. I think people were very pleased with the presentation.
Thank you, Dan.
Anyone have any questions? Well, with that said, again, as I said, thank you so very much, Reed. You did a fantastic job. I think it's a complex issue, but you did a very, very good job. I will be sending out a link to the recording of this webinar, the presentation, and the handout that Reed prepared. So be looking forward to that probably tomorrow sometime. If you have any questions in the interim, please don't hesitate to send those my way. And if I can't answer those, I'll forward them to Reed. With that said, thank you all so much for participating. Reed, you have a fantastic rest of the week, and I'll let everybody go. Thank you guys so very much.
Thank you, Dan. Thank you, everybody.